let's start with the benefits. Why do people actually like PKPUs? You know, bank creditors in Indonesia, the Indonesian bank creditors, they're not as hostile to the PKPU process as some of your foreign clients may be. They find it useful. Why? It's fast. As I said, it's 270 days maximum for the PKPU process. You either reach a compromise, debtor and creditor, or you go into bankruptcy proceedings and you already have the inventoried assets and they're liquidated. Compare that to civil proceedings in Indonesia. If your alternative to a PKPU is a normal civil proceeding in Indonesia, that's easily anywhere from 6 to 10 years before you reach a final and binding judgment. So the 270 days is a big advantage. Another advantage is that the proceedings are very simple, very flexible. It's like a gigantic 270-day mediation session. There is no rule as to when meetings are held, how often they're held, how they're structured, what the agenda is. The administrators, talking to the debtors, talking to the main creditor and the supervisory judge have tremendous flexibility as to how this process is operated. And that can be very useful in an emerging market like Indonesia, where you don't have the most sophisticated legal process to start with, to have a judge who's effectively able to attempt to mediate the differences between the debtors and creditors to reach a solution. A third reason why the PKP process is useful, is preferred, is it allows the court to ignore the terms of the debt itself. What's important is the maturity, the amount, and the security. And if you're an Indonesian judge and you have a very complex creditor like Modern Land that has foreign bonds, perhaps domestic bank creditors, trade creditors, those foreign bonds are extremely complex to understand and interpret by Indonesian standards. If you have, I was once a practicing U.S. lawyer in debt capital markets. An a New York law trust indenture can go on for 200, 300 pages, not to mention security sharing documents, the security documents. If you're an Indonesian judge and you have to attempt to deal with that in an Indonesian proceeding, that's just way too complicated. Whereas the PKPU process, you don't care what the New York law trust indenture says. All you care is how much debt is there? Is it secured? The rest of it, you go into the bankruptcy law. So it's simple and it's flexible. Another advantage is you have specialists, like you have that special ecosystem up there in Singapore. In Indonesia, the administrators are trained, they're certified, they're members of a professional organization with continuing legal education requirements, and they're specialists in this. There are maybe 10 names that are very well known in the administration world that you go to for a major PKPU. They know what they're doing. And finally, I'd say it's enforcement. It's extremely difficult, everyone knows, to enforce any type of judgment in Indonesia, whether it's an arbitration award or a court award. Getting the assets, getting a hold of them, enforcing is very difficult. Whereas in a PKPU, the administrator has signatory authority together with the debtor over all the assets which have been inventoried. The debtor cannot get rid of the assets. They cannot transfer them without the administrator co-signing. And if the PKPU fails and you go into the bankruptcy restructuring, the administrator then has sole control over the assets. Enforcement is very easy.